will discuss the very concept of negligence, and regarding that, the question is with the help of judicial pronouncement, discuss the essentials of negligence. And the other question is that what is contributory negligence? How far contributory negligence a defense? So, in relation to negligence, that we would like to discuss, negligence exactly means neglect of the use of ordinary care or skills towards a person to whom the defendant owes the duty of observing ordinary care and skill by which the plaintiff has suffered injury to his person or property. So, in the leading case, that is Grand Australian Knitting Mills in 1936, their lordship held that it is negligently or carelessly if some specialized breach of duty, then it would fall under negligence. So, in the leading case, Donoghue versus Stevenson in 1982, House of Lords expressed the similar opinion regarding negligently and carelessly if some specialized breach of duty one committed and which is already fixed by law. So now we'll discuss the essential conditions of liability regarding negligence. So one of the essential conditions is defendant's legal duty to exercise due care and skill, and second one, that is breach of that duty which is already fixed under law, and the third essential conditions of liability relates to that the act of the defendant result in direct consequences or injury or damage to the plaintiff's person or property. And now we'll discuss exactly the position of burden of proof. And here, under negligence, the burden of proof always lies on the plaintiff. So, and as it was decided in the leading case, K.C. Kumanan versus Vallabh Das in 1969, it was expressed by their lordship that burden of proof always lies on the plaintiff, and if it would finished on the part of the plaintiff, then the defendant to prove it as inevitable accident or contributory negligence on the part of the plaintiff. And now we'll discuss the very maxim res ipsa loquitur, which relates to the very concept of negligence. And exactly res ipsa loquitur means the thing that happened speaks for itself, and the very maxim res ipsa loquitur was first applied in the leading case Scott versus London and St. Catherine Docks Company 1865, where the London High Court expressed that under the management or his servant of the defendant, if accident not happened in ordinary course of the thing, if proper care was taken, then it would be considered as negligence on the part of the defendant, And in another most important leading case, that is Chairman cum Managing Director Bihar Road Transportation Corporation versus Manju Bhushan Sinha in 1992, their lordship expressed that accident always tell its own story or speaks for itself. This is the defendant to establish that the accident happened due to some other cause than his own negligence. And now we'll discuss another question. What do you understand by trespass? What defenses may be available to a defendant in case of trespass, and explain the very remedies for trespass to land. So, exactly, trespass means wrongful disturbance of another's possession of land or goods. Then it always considered as infringement of a legal right of the defendant, of the plaintiff. So, trespass by wrongful entry and trespass by abuse of lease or license, trespass by placing things on the land, and trespass by cattle. All these are different kinds of trespass to land, and here the court can award both nominal damages and special damages. And now we'll discuss the very conditions required for trespass, actual and effective possession by the plaintiff, and there was direct interference in that possession, and those remedies available under trespass, the plaintiff may bring an action or forcibly can eject the very defendant, also may obtain an order of injunctions, and those defenses which are available regarding trespass to land are prescription, and the second one leave and license, and the third one by authority of law, and the very act of necessity and self-defense, re-entry on land or retaking of goods and chattels, and these are the defenses available to the defendant in all cases of trespass to land. And regarding trespass to goods, it is always means and includes crime of theft and robbery and killing or injuring animal or defacing any work of art, and these are considered as trespass to goods. And the very essentials of trespass to goods are actual or constructive possession. Then it must be wrongfully disturbed by the defendant. So persons can maintain actions, those who are eligible under law to maintain action against trespass to goods, such as the owner and also in possession of the goods, then actual or constructive possession by a servant or by a bailey or an agent, and Even a trespasser could maintain an action against a stranger on regarding trespass to goods. So also, a finder of an article, even if he is not the actual owner but was in constructive possession of that article, he could also maintain an action under trespass to goods, and also a joint owner against his co-owner regarding any damage or anything caused to the goods in joint possession, and those defenses which are available under trespass to goods or self-defense of property and seizing goods under lawful distress as example for collection of rent, and also another defense, that is legal authorities has the right to trespass to goods. So also negligent and wrongful act of the plaintiff, where also it would be a defense against trespass to goods, so also rightful claim. So these are the defenses available in regards to trespass to goods. And regarding all these questions on law of tort that we have just discussed, besides those answers, those most important tort maxims already that we have discussed in length and in detail in our previous videos, which we have already uploaded in our channel. So for these detailed answers regarding all these questions and regarding all those maxims or taught principles, it is my request to all the viewers to kindly go to our previously uploaded videos on the very subjects which are part of law of tort. So also all those maxims and tort principles that already we have uploaded in our channel,